2. I think I see. Mr. Cook, are you able to hear the court?
Yes.
Okay. What I did receive from you, thank you both. You guys have clearly been working diligently to get this new parenting plan put together. I have received all of your documents that both of you have signed. This includes the final order regarding the relocation that you both have signed, the motion for final order to change a parenting plan. I have the actual parenting plan that both of you have signed. And I have 2 residential time summary reports. That was the only document I had a question about. If I have 2 different versions, one puts 60-40 and one does 80-20, but otherwise they look the same.
So the 80-20 is directed towards Logan, the more longevity of the parenting plan. The other one, I wasn't quite sure because it's for Xander, but Xander ages out when he, in December.
Okay. So it sounds like the 80-20 is going to be more applicable long-term to the case.
Yes.
Okay. Mr. Cook, is that your understanding as well?
Yes.
Okay. I think that's the one I'm going to file with your final parenting plan. Any objections, Mr. Cook or Ms. Kaufbelt, to the agreements that the orders that you both have agreed to and filed with the court? I did review them in detail, and I think they all comply with what we previously talked about. So I guess this is your last chance to make any objections or have me rule on anything. Otherwise, I will sign these orders as presented.
Nope, I have no other objections.
No objections.
Well done. I mean, this kind of started out a little more contentious, and I think you guys ended in a really good place. So I credit both of you for working together on this. So let me just make sure I get everything signed for you. Anything else I can do for the 2 of you? It does not sound to me like we need any review dates. So for now, I think you guys are done with your court appearances here.
Okay.
Yep. Thank you very much.
All right. Thank you both again for working together on that.
And Beth Fellows, GAL is present as well.
Good morning, Ms. Fellows. Thank you for being here. When I reviewed the last hearing when we were all together, my understanding, we're doing a couple things today. One is we're going to get an update on the ROIs from Ms. Shoemate. Number 2, we're going to discuss Mr. Weiss's motion to waive mediation. And then depending on the outcome of that, we're going to talk about where this case goes in the future. Does that sound right to everyone?
Yes.
Yes, Your Honor.
Okay. So I guess I'll start. I don't know, Ms. Fellows, if you have an update for the court on the ROIs and where we're at with that.
I do not, Your Honor. I have been out of town, out of my office, so I don't have any information on whether or not she's provided more ROIs or not.
Okay, totally understandable. Mr. Weiss, have you received any additional ROIs or corrected? I know one of the issues was we were waiting on corrected ROIs. Have you received any of that?
I haven't received anything since last court hearing.
Okay. So Ms. Shoemate, I'll turn to you now. I think, as you know, we originally were here on a motion for contempt over some of these issues. I didn't find contempt, but I did set deadlines for you to get those things done. We came back July 19th, and we were still waiting on the corrected form for one of the school districts and then any forms for other school districts. Where are you at with that?
I just received Vancouver's yesterday. So by the time I got off work, I wasn't able to file it. And then for the one for Wakaikam, the one that is not correct, the ROI, I did get a hold of the school and talk to the superintendent. That's the only ROI they have. And he said that they know that if Kyle calls, it's for him. So I don't know exactly what to do for that one.
Okay. And then what about Rochester?
I filed that one, I believe.
We didn't have it on July 19th. Have you received it since then?
I know I have one from Rochester. I thought I filed it on the last hearing, last Tuesday, I believe.
We did not have it last time. So let's do this. I guess I'm not sure. So Mr. Weiss, what we'll do with the Wahkiakum form, we will set a review date. And if you have difficulties using the form that they've presented, certainly bring that back before the court and we'll address it. I feel like my hands are a little bit tied if the school district is saying that's all they have. But Ms. Shoemate, I'll have you get the ROIs for Vancouver over to Mr. Weiss. If you haven't given him Rochester, you need to do that.
Okay.
And then I think we had taken care of the medical facilities.
Yes.
So let's just do, and it should be a pretty quick appearance next Wednesday at 9 a.m. just to make sure that he has received all three of the ROIs for the school district. Mr. Weiss, if you have by next Wednesday, you could strike that review that. Let's talk about the waiver filed for mediation. Ms. Shoemate, have you received a copy of that?
I just got the email from Kyle.
Yeah, so we had originally discussed this at the last hearing, excuse me. So although it technically, I think, Ms. Shoemate, if you wanted to object and have us hear this next week because of timing, that's fine. But my thought is if Ms. Shoemate, you feel ready to proceed on that today, the court would just be hearing from the both of you as to whether or not to waive mandatory mediation.
We can do it today.
Okay, I think that makes sense for you all in getting some resolution to this. So what I have done is I have reviewed the declaration in support of waiving mandatory mediation for Mr. Weiss. I have received it. And reviewed it. I did also go back and just review notes from our last hearing where this was discussed briefly. And essentially, Mr. Weiss is asking this court to find that given how far apart the parties are on issues related to kiddo and how contentious a lot of this has been, including motions for contempt and that sort of thing, that mediation would be highly unlikely to be successful. Mr. Weiss, I know your position. Ms. Shoemate, what is your position on that?
I would like to do mediation and be adults and co-parent. Last time, I believe it was like back in 2018 or 19 when we first did it, we didn't really have problems doing it the first time.
Mr. Weiss, any response?
Yes. The first time we did it, there were several, and I mean several incidences and circumstances that were different. Everything is completely different compared to the first time we've done it. I mean, I could go on and on the reasons why mediation is probably not going to work. But yeah, I just don't think we're going to be able to agree.
And Ms. Fellows, any input on this specific issue?
Yes, Your Honor. I did read over the father's declaration, and that's one of the reasons why I said what I said last week about mediation, that I did not think it would work. This case is not suitable for that platform. They are too far apart. There's been a lot of things that have happened. These are not two parents, unfortunately, that are going to be able to move forward co-parenting. And they're nowhere near the same ideas on the custody matter. And there's just so many issues, and there's no common ground. So I really do feel like mediation is not the platform for these parents.
Okay, I appreciate that. So here's the court's ruling. I am going to sign the order waiving mandatory mediation. I do find there's good cause to waive mediation in this case. I would say, Ms. Shoemate, I, just in my brief time being involved in this case, have had to hold your hand through a lot of things that I feel like could have been done without court involvement. So I just don't see how this case concludes quickly without court involvement. So I have signed the order waiving mandatory mediation. I have filed that with the clerk. What I think we need to do now then is get a date for the two of you to get on our trial setting docket, so you can start thinking about how far out you want to get a trial to finalize orders in your case.
I'm good for next Wednesday if it's open.
What about you, Ms. Shoemate?
I have to give a 2 weeks notice to get that day off.
Okay. What about, would Wednesday, August 9th work for you?
Yes.
You may want to clarify that this is just a short little hearing just to set the trial date. It's not for the trial itself.
Yes. Thank you, Ms. Fellows. I sometimes forget when folks don't go through this process every day. So for both of the parties, it's called trial assignment. It probably will take less than 20 minutes all said and done, meaning 20 minutes for everyone on the docket to get trials set. So your particular case, probably a minute or two. And they'll be asking, how many days do you anticipate needing for trial? And what month are you thinking you want the trial to take place? And then they'll give you a week where they'll set your trial date. Does that make sense?
Yeah.
Okay.
I'm a caregiver, so they just need to find somebody to be there until I'm done.
Yeah. So let's go ahead. I can put this on the August 9th trial assignment docket at 1:00. Any questions for me about what we've done today? You have next week a review on the ROIs on this docket at 9 a.m. And then you have the trial assignment the following week, Wednesday, August 9th at 1:00.
Your Honor, I did have a question, and I'm not sure that you can answer it. My last report was filed, I believe, in December of 2021. There have been a number of things that have happened between then and now. And if we're going to trial, would the court like an updated GAL report or not?
That is an excellent question. And I think with these two proceeding pro se, I do think an updated report, albeit it doesn't need to be as lengthy as the initial, obviously, but I do think an updated report would be beneficial for the parties' preparation for trial, as well as the court understanding how long that trial might need to take place. So I do think that's a great idea. Do you need approval of additional hours or fees for that?
Yes, please. That would be much appreciated.
Okay. If you want to submit a proposed order for me to sign based on today's essentially ruling, that we will need an addendum report and the parties are moving forward to trial. And if you send that to my attention, I'll make sure to get that signed.
Okay. Okay. Thank you, Your Honor.
Yes, thank you. And then maybe what we'll do, since we are going to keep an eye out for that, maybe we set a review about 30 days out, or do you want a little more time?
I would say a little more time. Let's see, 30 days out would put it at the end of August, maybe mid-September.
Okay, let's do like September 13th.
Okay.
At 9 a.m. for review of GAL addendum report.
Okay.
And then Mr. Weiss and Ms. Shoemate, what I'll just tell you is you could go ahead, you can still go ahead and set trial. I would just set it beyond September 13th. So you both have the benefit of that information. And frankly, you're probably not going to be offered trial dates before September anyway.
Okay.
Yeah. Any questions?
None.
No.
Okay.
Thank you, Your Honor.
Yes,
don't
thank you
off
all. The bat see either of the parties present. Are we expecting them?
I was expecting my client. I know she's had difficulty with the technology, but I don't see her either.
I would suspect that father likely is not going to appear.
Okay.
Managing these deadlines has been pretty challenging for him. He's also an inpatient right now, so I don't know that he has access.
I did see that from the guardianship case. I don't know, Mr. Anagnosto, Ms. Smith, in light of the party's absence, should we renote this? Or we can wait a few minutes. It's really up to you all. I did review the guardianship update, and I did see that update about father and inpatient.
And usually the guardian is here, and I don't see her either.
Ms. Smith is the GAL.
Yeah, not the GAL, but the petitioner.
Oh, I gotcha. From the minor guardianship. Thank you. Right. Yeah, they're not on either.
It's my understanding that she typically just observes on YouTube, as she's not a party to this case.
Yeah.
I guess my suggestion to the court to consider is maybe, and if Mr. Anagnosti would be agreeable to this, is just having it noted at a later date, setting it out for another 30-day review, given the status of the minor guardianship. I was just wondering if Mr. Anagnosti would just prefer to set it for hearing once the minor guardianship has been dealt with. But again, I guess I would defer to the court and Mr. Anagnosti.
I mean, that makes sense to do it that way. And this was set up by Commissioner Nelson to go along with the guardianship case. So, yeah, I mean, it makes sense that we do that.
Okay. Just looking to see when the next, looks like the next guardianship will be August 17th. That's your next appearance on the guardianship. That's when they're going to review some additional requests for visitation, perhaps, or just review the visitation, I guess it says. We'll consider limiting visitation during the next hearing. So do you want to set this out on our first docket after August 17th?
That's what we've been doing. And then we end up having this hearing in advance of the guardianship. But I think that's what we should do. Yeah.
Okay.
I think that would be preferred.
Okay. Let's do September 6th at 9 a.m. I'm comfortable with that because there is that tracking minor guardianship case that's addressing most of the same issues. So unless the parties have something on the family law front solely that comes up, you certainly feel free to note it on sooner.
And is that date okay with you, Ms. Smith?
I'm not seeing any of those parties present.
No, and I have been contacting this morning via text and phone, and I'm not able to reach either one of them.
Okay. This was on for, let's go ahead and just call this case and chat about it for a minute. This was on for pretrial management, which does give me some pause for whether they're going to be ready to move forward to trial. Ms. Turnbull, do you have any update on that end? And I don't necessarily expect you to, but there's no one else to ask.
Quite frankly, I am not sure either one of them really know how to prepare for trial. Mm-hmm. So I'm not sure that, I think that they could use some guidance, quite honestly.
Trying to see, so their trial's the week of August 14th. They do have readiness scheduled for August 8th. I'm tempted to renote them for next week back on this docket for pretrial management to go through that with them. Otherwise, my worry is they're going to go to readiness August 8th, not knowing what to do, and their trial might be a strike.
I think that would be a good idea.
Okay, so let's just note their non-appearance in the notes today. I'm not sure what's going on. We have many folks not appearing today for some reason. Let's renote this to our August 2nd, 9 a.m. docket as a continued pre-trial management hearing. And we'll see if we can get them online for that.
I will reach out to them and let them know.
Okay. And does that date work for you, Ms. Turnbull?
Let me double check.
And Ms. Looney, I know you're here on this matter also. Does that work for you? Their readiness?
It does, Your Honor.
Okay.
Thank you.
All right.
And then on the Dale B. Ranger Creed matter, I don't expect the respondent to appear.
Okay. Do we have the petitioner on that one either?
Yes, she's here.
Oh, Ravendale is there. Okay. Let's go ahead and call that matter. This one I know, I believe, Ms. Turnbull, you were just appointed a few weeks ago.
That's correct.
Case. I'll turn it over to you in just a minute. In getting up to speed for myself, the only order I have in front of me that's been presented by Ravendale is a restraining order.
There should have, is that part of the parenting plan as well?
Well, I see that you filed it with the court. I don't have, let me just go back through my stack, but I don't think I have any other orders to sign. So sometimes, and I understand, sometimes they get attached to the back of other orders. Yeah, not seen any other orders for signature. So often, especially unrepresented folks, there's a difference between just filing it with the court and then also giving an original order to present to me. And that's probably what's happened in this case. Ms. Turnbull, any input? Have you been able to talk to any of the parties yet at this point, or?
Yes, I have. I have been down and interviewed Ms. Dale and met with Kiddo and seen her home and her family. I have received the collateral contacts and I have no concerns there. I think Kiddo's well bonded and in a good, safe place. Respondent, no contact. I've tried to reach out to him several times and he is not returning my emails. I don't have any other way to contact him. I don't have an address. I have no phone number. Just an email, and he's not responding. So I'm not sure how else to reach him at this point.
Okay. Ms. Dale has responded, made any attempts to be in touch with you or Kiddo?
No.
Okay. Are you, I'm going back and reviewing the notes from the last hearing, and it does look like we signed the temporary parenting plan at that point. So that's why it's not in front of me today. Oh. And we just simply reserved on the restraining order. That's why that is in front of me today. Okay. Are you still requesting a restraining order be signed?
Yeah, if we could just have that kind of as a backbone, I would feel better.
Well, let me ask you this though.
Not really around. So I'm not.
Yeah, so I'm not going to sign a restraining order against someone just because you don't want them around and you want it as a backbone for a case. There really would have to be enumerated reasons for why a restraining order is necessary to protect yourself and or kiddo.
Right.
So
Yeah.
the question is whether there's been threats of harm or actual harm that we're trying to prevent through a restraining order.
I would say the only harm that really honestly took place was when we were living together and in a relationship. There was some domestic violence and stuff, but since separating and him kind of not being around, I think that's okay. I don't think there's really a threat of him coming back around anytime soon, honestly.
Okay. Do you have any idea where he is currently?
No, honestly. I had heard on it just like through word of mouth in a small town that he was kind of couch surfing with friends out towards the Castle Rock area, but I couldn't even pinpoint an address of who or where.
So I think what I'm going to do today, I'm not sure I have enough information to approve a restraining order today. So I'm going to deny that at this point. However, that does not in any way preclude you from re-raising the issue should there be threats of harm or harassing behavior starts up. Certainly feel free to bring that back before the court. We also do have a civil protection order docket every Monday. You can always apply for that, and those have emergency orders that can sometimes get approved same day, depending on the type of behavior that you're reporting.
Okay.
So those are both avenues for you today, but for today, I'll go ahead and just deny the restraining order. It does not sound like I would have grounds to grant it at this time. And then we do have the temporary orders in place. So I think at this point, and Ms. Turnbull, your feedback is helpful. I think at this point, we'll just set a review date for your report and come back and make some decisions about how to move this case forward at that time.
Okay. Yeah. So it's all right with you if I go ahead and move forward, given Dad has had no follow-up whatsoever.
Correct. I think, yeah.
Great. Okay. Fantastic.
Okay. Ms. Dale, will that work for you? We'll have you come back August 30th at 9 a.m. on this docket. And
yeah, I can try my best. Sorry to cut you off.
Does that work for you?
Yeah, I can try my best. I'll just, have to run it by the HR department and all that, but I'm sure we can figure it out.
Okay. I would also say if he's not going to appear at all in this, what we'll do is we'll set that as a review for the GAL report and recommendations, but assuming we still just have no response from him, Ms. Dale, the court can consider entering orders at that time if we just have no response from him regarding final orders. You have temporary orders in place.
Okay. So if there's nothing from him, August 30th would more than likely be like the final hearings and stuff.
It could be if we have orders for the court to sign and they're in line with what the GAL is recommending and he doesn't object. Yeah, I don't see any appearance from him at this point. So,
yeah.
Okay.
Would you like Ms. Dale to bring those orders to the court or present those orders?
That would be helpful, but I also understand in a situation like this, that may not happen. And if it doesn't happen, I'm happy to prepare them.
What orders are they? What am I supposed to?
So you had originally filed the parenting plan proposed order. So this would be the same thing, just final. Instead of temporary, the court would be considering whether to enter those as final orders.
And would I have to serve those papers as well to the other party?
And I'll get some feedback from Ms. Looney. Since the state's involved, I do believe you would need those, correct?
Sure. I wouldn't need copies of the parenting plan, but I just wanted to request, if we're looking at potential final orders on the 30th, that we also note it for final child support orders at the same time.
Let's do that. So you don't need her to serve the parenting plan on you? Okay.
No, Your Honor.
Okay. So let's do that. Let's also indicate that August 30th potentially is our final child support order presentation as well. So Ms. Dale, if you want to prepare a final parenting plan for me to review on August 30th, you would just file that with the court.
Okay.
Okay.
Okay. I will do my best to get.
And yeah, and I'm sure you and Ms. Turnbull will talk before August 30th, and she may have some input for you. Okay.
Okay. I'll see you then. Thank you so
All
much.
right. Well, this is a temporary family law order with, oh, sorry, wrong one. Your motion for default.
Yes, ma'am. I filed for dissolution and then motion for default and set today's date because I haven't had any traction from the other party in terms of moving forward.
Yeah. And I see that I did review this. I did review it for service. I do see that he was personally served.
He was on June 9th, I believe, the day before my son's graduation.
Yeah, so. June 8th is the date that the process server indicates that they did personally.
Oh, okay. I knew it was around there. Sorry.
It's okay. Yeah, I'm just trying to make a record. So I'll come to you in just a minute. So I do show, I'm going to change the date. You put June 9th in here. I'm going to change it to June 8th. That is more than 21 days ago. It does appear that the court has jurisdiction over this case as all parties reside in the state of Washington. The original petition was filed with this court on April 19th, which was less than a year ago. I don't see any indication in the file of a notice of appearance or response from respondent Jeremiah Fletcher. Ms. Fletcher, have you received anything?
No, ma'am.
Okay. The clerks caught something on this order. I need to change. I think you had originally put your name as the party in default. So they left me a note making sure we changed that to his name. So let me get that done.
I appreciate that.
Yeah.
I've never been divorced before, so I'm doing this all by myself.
I understand. And that's why they're so good at what they do. They catch things.
They are. Well, and I didn't expect them to be so helpful when I went into the clerk's office, and they've all been very helpful and amazing. So kudos to them.
Good. Well, I have made those two corrections to your order, and otherwise I have signed it as presented. Okay. Then I think what we need to do is just so we have this motion for default. That essentially means he hasn't appeared and you get what you're asking for, assuming it comports with the law. I still have to review it to make sure that it is something the court can order. So what I want to do is set a future date for you to present permanent orders. So that would be the dissolution, the parenting plan. If there's state assistance involved, the prosecutor's office would be responsible for setting child support payments.
What do you mean by the state being involved?
So are you requesting child support?
I am for my daughter. Yeah, my son's 19, so he's not.
And then does kiddo receive any state assistance?
Oh, no, ma'am.
Oh, okay. So there's no state medical or TANF?
No, she has medical through her dad. He's ex-military, and it's free to him to have her on his insurance for medical. And then I pay for her vision and dental through my work.
Okay. And just because you mentioned military, he's not active duty. Because I think
been out since 2006.
Okay. Because on that, you had checked that he is not covered by state or federal Service Member Civil Relief Act.
No, because he's not active duty. He's been medically discharged, I guess you would call it. He has his DD-214. He's no longer active duty.
Okay.
That's the way that I read the documents, was he had to be active duty for me to fill out that section.
It would be active duty, or if they're reserve members under a call to active service.
No, ma'am. He's completely out of the military.
Discharged. Okay. Okay. Just wanted to check since you did bring that up. So, you had originally presented a proposed parenting plan in your petition for dissolution. What we would need to do is just set out a final date for you to supply your final request to this court to sign.
Okay.
I'll tell you, if you're doing it without an attorney, we have, when are the court facilitators here?
That's actually me.
Oh, it is you. Perfect.
We do those on Friday mornings, afternoons. They rotate. So you just have to come and drop off our final papers and sign.
And then you guys like look them over before they get here.
I meet with her.
Perfect. Okay. So
that's an in-person thing on a Friday.
Let me get to, yes, you would come in person with your proposed orders. And you said Fridays.
Well, she has to come in and sign a disclaimer, leave her final papers, pay a $20 fee.
Okay.
And they'll set the appointment at that time.
Oh, perfect. Okay. I have the scoop. So you come in on Friday to the clerk's office. You're going to submit your final papers, your final orders. You're going to pay $20 and you're going to sign a disclaimer. And then at that point, they will set up an appointment with you.
For the court facilitators.
For the court facilitators. This is a way for you to have these final orders reviewed for any issues or things you've left blank or things the court can't sign before you come back in front of me.
Okay, that's perfect. Yeah, because I have no idea.
Yeah, I think it's a great service. I encourage you absolutely to do that. And then
I can do that Friday actually, because I have Friday off.
Well, we can give you some time. When do you want to come back and present those to me, and take into account you'll need time for that court facilitator process?
Let's see. And we only have available dates because of my case number on Wednesdays, correct?
Yes, we're going to, yep, your case will track on a Wednesday at 9 a.m.
Okay. I'm going to come this Friday to do the disclaimer fee and get all of that situated. So I guess it would just depend on my earliest available appointment with the facilitators to dictate whether or not, I mean, I'm not sure how far out that is. So maybe 2 weeks from today.
How much?
We have appointments are only available right now on August 11th or 18th. I'm already up till then.
Got it. So, even if you did it like today, the soonest they'd get you in is like the 11th or the 18th. So why don't you just set this for August 30th, Wednesday, August 30th. It's about a month out. And the plan would be that you present final orders to the court at that time.
Okay.
If for some reason, don't stress if the facilitator's appointment's further out, or if you can't get here this Friday, so it gets set out further. We can change that date. We're not in a time crunch here, so don't stress if the timing doesn't work out.
Okay.
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 All right.
And then aside from final orders, is there anything else that I need to bring on the 30th visually, obviously?
No. Mm-mm.
Okay. And then to submit final paperwork, do I need to resubmit everything that I've already filled out, like refill out everything and resubmit it to the court? Or how does that work?
Yeah. And I don't think that you submitted everything that you're going to need. So in a dissolution, I do see the temporary parenting plan, but you'll need to do final family law orders. Perfect. Okay. So yes, on the court clerk's website, there's a list of all the documents that you'll need, because you can get those through, it's called Administrative Office of Courts. They have all the family law court forms. You can also come into our clerk's office and get that list.
Oh, okay. I might do all of that on Friday. Just come in early. That way I can get everything done, because I have the whole day off. So might work out best.
Okay.
And, there's also going to be fees for printouts of paper, correct? So I should bring money in addition to the $20 disclaimer fee, correct?
Yeah, if you're asking our clerks to print them for you, then it's 50 cents a page. But you can get the checklist of all the documents you need, go to the AOC, Administrative Office of Courts website, and print the forms yourself.
Okay, I'll probably have, I don't have a printer aside from work, and I work in Vancouver, so I'll probably just have you guys print them out for me.
Okay.
So we'll see. August 3rd. Got it.
Okay, sounds good.
Just one quick question. Do I need to continue to stay on the call, or can I log out?
Nope, you're free to log out now.
Okay, thank you. I appreciate it.
Yep. Can you hear the court, Ms. Linden?
Yes, sorry. I had a message from my dad.
Oh, no, you are fine. I am not seeing in this case. I'm just going to double check again. I don't have proof of service on the respondent, Mr. Adams.
I only got a picture of it because my sister, who's not dealing with any of this, was willing to serve but hasn't been able to mail it back yet due to her work.
Okay. So, and is it like a declaration of service showing like what she served and when she served it and how she served it?
Yes.
Okay. So I can't do anything today without that proof of service on him. If he was here, I could ask him whether he's been served, but since he's not, I can't move forward with approving any of your requests today. I do need the proof of service. I can reset this case for a different day if you tell me how long you think you need to get that document filed with the clerk.
I can get it filed today.
Okay. So I'm also just going to let you know you would have to serve him with notice of the new date. So I'm thinking, is he local?
He is in Raymond, which is why I had difficulty trying to serve him.
Okay. Well, then I'm thinking we would set this out 2 weeks because he will need to be served notice of the new hearing date.
Okay.
Okay. So would August 9th at 9 a.m. work for you?
Let me see my schedule real quick. I can try.
If there's a better date, let me know.
I would just probably have to request the day off.
Okay. Do you want August 9th or do you want a different day?
I can do August 9th.
Okay. So we'll set you to August 9th at 9 a.m. And I'll just need the proof of service of the original, the summons, the petition, the temporary orders you're requesting. All of that I need to make sure he's been served with.
Okay.
Okay. All right. Any questions for me, Ms. Linden?
Yes. He wants to have our son, but he is currently threatening that he will, when he does visit him, that he will never let me ever see him again or have any contact with him.
Right.
So is there any way to make sure that he wouldn't do that? Or couldn't do that?
I did see those allegations in your documents. not seeing, and I'm not seeing a request for a restraining order. What I would recommend is if there's been threats of, leaving with your child, that is part of your proposed orders, that you may want this court to consider a restraining order.
Okay.
But I can't, I think you had marked no request was made for a restraining order. So you may want to amend your temporary family law order that you sent to the court. You may want to amend the last page to request a restraining order, and then we could have a hearing on, whether the facts justify that.
Yes, ma'am.
And then I would just say in the meantime, obviously, not letting you have access to your kiddo would not be lawful. You certainly at any time can call law enforcement.
Yes, ma'am.
Okay.
Does that mean that if his dad does do that, that I could get him back?
Yeah, so I'm not going to go further down the path of giving you legal advice. If you need legal advice, you can reach out to legal aid clinics.
They already told me not to give little man to him if he's going to do that.
If that's legal advice that you got, I'm not going to comment on it. So as a judicial officer, I receive the information and make decisions. I can't be in a position of giving you legal advice.
Yes, ma'am.
Okay. All right. We'll see you back in 2 weeks.
All right. Thank you.
All right. Best of luck.